Friends, welcome to the 257th session of Legal Empowerment through Interaction lecture series. The journey continues. Today we have a very interesting subject. The day after the Constitution Day, we have constitutional obligations of places of work and of worship. This is in fact part 2 of the talk we had earlier. Sri Giridhar had enthralled us last time with the first session. Now today we'll be having the second part, and let us get ourselves involved in these things, because this is something that has to be critically seen, for one thing. And today we are privileged with the presence of Justice V. Ramkumar sir, Justice Ramakrishnan sir, and all of you wonderful participants. And without wasting any time, may I go straight over to Giridhar sir. All yours.
Thank you, Shyam. I'll share my screen and begin.
Yeah, I have enabled that, sir.
Thank you.
You can.
Follow.
Visible, sir.
Visible? Okay.
Yes. Very much.
Just 1 minute. So good afternoon.
Okay.
Can you hear me? You can hear me?
Yes. Oh, yes.
All right. As Shyam just stated, this is part 2 of my talk. This last time I spoke generally about the constitutional obligations of non-state institutions, which I called fourth branch institutions. That is, conventionally 3 branches of government are recognized, but there's a fourth branch which mediates various relationship between various constitutional players, which are not within the conventional understanding of the state, the definition of state, particularly not under Article, even though it may be a state under Article 12 of the Constitution, like for instance, the Comptroller, Auditor General and the Election Commission. They may, as explained, as propounded by the Supreme Court in Andi Mukhtar Trust case in 1989, in Janet J. Paul's case that's later, the certain institutions, even if they are not state within the meaning of Article 12, they are persons or authorities to whom writ could be issued under Article 226, since they have public obligations which are similar to state obligations. I'll quickly finish up 3 or 4 introductory slides for those in this group who are not there, so that I can get into the specifics of the obligations of place of work and place of worship. This is what Dr. Ambedkar said on 26 January. And he said that we are going to enter a political life of formal equality, where every person has one vote. But in social and economic life, there is no equality. And therefore, the kind of social democracy that is needed to ensure that there is balance, not just in formal politics, but in social, cultural, and economic life, was going to be a struggle. And hopefully, we express the hope that the Constitution would pave the way for such a transformation. So I also spoke about the origin of the state in political theory, where the divine right theory was the origin of the state, where the state and the king were understood as representatives of God on earth. And law was the command of the sovereign, but was an extension of God's law. So if you disobeyed the king, you disobeyed the representative of God. That was the rationale and legitimization of the state and kingship in ancient times. Then came social contract theory through people like Hobbes, Locke, and Rousseau, who argued that the state was not a divine creation, but rather a contract between the ruler and the ruled, where the ruled, that is the people, surrendered their liberties to the king so that he could protect them from external danger and internal dissension or disorder. However, Locke and Rousseau differed from Hobbes to an extent, where Rousseau said the king should always represent the general will of the people, and Locke said even though certain liberties have been surrendered to the state, in the course of the contract, there are some inalienable natural rights, which we today recognize as fundamental rights and human rights, in the political lingo of that time, or jargon of that time, he calls them natural rights, which are born with the moment a human being gets born. And he argues that such natural rights can never be taken away by any king or any state, whether it be an oligarchy, monarchy, or democracy. And if one studies Western European history, particularly British history, one sees that it progressed from monarchy to oligarchy, and post the French Revolution and the so-called bloodless revolution in England, democracy gradually gave way. And even in places like Belgium and Britain, where monarchy survived, it was a constitutional monarchy where the king was more a ceremonial and nominal figure, while the parliament and the group of ministers who are responsible to the parliament, we actually exercise all political and executive power under the constitutions, whether written or unwritten. So that was how, so much so today, even though Britain is a monarchy, one finds strong, robust democratic institutions, and rights are enforced very much by an independent judiciary, despite Parliament being supreme and Parliament having the powers, unlike untrammeled by limitations like in India. We find that the culture and conventions are so strong that they dare not interfere with the liberties of the people, which have historically been evolved from the Magna Carta to Bill of Rights and Petition of Rights and so on in British history. So democracy has taken root, not just in formal constitution, but in the culture and conventions of the institutions that guide the institutions and the culture of the common people. Unfortunately, in India, we have dual culture. At one level, the culture of the people is guided by caste, patriarchy, and certain loyalty to religion, sometimes to the extent that my loyalty to my religion is antithetical to another person's loyalty, and we go after believers of other religions with a vengeance, and often to the point of treating them as enemies, which also Ambedkar points out. And in such a situation, the culture, or one aspect of culture, becomes a danger to democracy, particularly social democracy, not so much as to formal democracy, but even the institutions of formal democracy could suffer under such conditions. So if you look at constitutional where the Constitution operates in the intersection between the state, society, and law, and the relationship between these three institutions. And historically, from divine right, we moved to social contract, and social contract to rule of law. And rule of law was an institution under which it is not just the ruler, but it's not just the ruled, but the ruler also had had to comply with the rule of law. Secondly, so therefore you will find that it is not only rights of citizens which are limited, but powers of the government are more limited. They are limited in terms of the source of power. They are limited amount in terms of the nature of power. For instance, if it's a judicial power, judiciary cannot exercise legislative power, and so on. Similarly, if it is the width of the power, depending on whether it's a power granted to act in an emergency or in a particular situation, the conditions for exercise of such power, the ambit of such power, and there are numerous kinds of limitations on power, which fundamental rights are not the only limitations of power, though we lawyers tend to think that whenever you talk about a limitation on power, it's only the fundamental rights. No, if all powers are traced to the Constitution or some statute, and we need to examine the statutory provision which confers power on a particular authority or on a particular minister or a particular institution, and that statute determines the width and the depth and the nature of power. And accordingly, judiciary, when interpreting the extent of such power, goes into these issues, which we cannot lose sight of. That is why the Constitution is not just a matter of relationship between state agencies, but it's a wider document. And looked at, at one level, we can look at the Constitution as an instrument of governance, and at another level, you can look at it as an instrument of social transformation. So it is both simultaneously. As an instrument of governance, it's a kind of a status quo institution which tries to maintain the order. As an instrument of social transformation, there are multiple provisions in the Constitution, ranging from 14, 21, 16, and so on, apart from the directive principles of state policy, which says that the state should move in a particular direction to ensure a dignified life to all people. And the dignified life should be granted in accordance with the law and the constitution. So you will find that in the constitution, there is a dynamic between the state and the nation. Often constitutional players tend, particularly the government, executive government tends to conflate the state with the nation. It is not often, state and nation are two different things. State is there for the nation and it is not the other way around. Nation is a much larger subject. For instance, it is often, for instance, in Jammu and Kashmir or in Punjab in the heydays, it was believed that by strengthening the state, you will strengthen the nation. But it is not so, because nation is something which resides in the feelings of people. I feel the nationalism, the spirit of nationalism and the spirit of belonging to the nation. And if you brutalize the state, its laws, its coercive machinery like the police and the army and the paramilitary, then the nation will actually shrink. So this is a dynamic which needs to be understood. And if we are talking about constitutional provisions and constitutional rights, when you are talking about constitution as instrument of state, it has to be limited government, limitations on the state, and expansion of the nation, so that the people are able to come alive. And that is why the constitution starts with we the people. So when the constitution starts with we the people, the constitution is talking about the nation. There are some provisions like part 5 and so on, which talk about the state. So it's very important to delineate what are the provisions of the constitution which deal with the state and what are the provisions of the constitution which deal with the nation. So if you look at constitution as a transformation, document of transformation or instrument of transformation, it is important to view what are the social relations that the constitution governs. So it governs the relationship between state and citizens. The examples are Article 16, Article 19, and so on. Article 19 is interesting. 19 too. I'll come back to Article 19. States versus persons. Article 14, 301, which guarantees free trade between states and so on. State versus states, 246, which regulates the relationship between legislative relations between state and center. 226 regulates relationship between the judiciary and the executive and also the legislature, because in exercise of 226, even state laws or union laws can be quashed as ultra vires. Persons and citizens versus persons and citizens. For instance, Article 21 applies to all persons. Article 19, however, applies only to citizens. Social groups versus states. 15(1) and 3 talk about women and backward classes. Social groups versus social groups. Article 17, for instance, says untouchability is abolished, which means that no group or caste can be treated as untouchables. And in the Ayappa entry, women's entry judgment, Supreme Court has dealt with this aspect and said exclusion of women from entering the temple can amount to untouchability, which is prohibited in Article 17. Though in the past, Supreme Court has refused to recognize untouchability in other spheres other than as flowing from historical injustices suffered by Dalits and other tribals probably. Social groups versus persons and citizens. So 15(2), Article 301 talks about traders, rights of traders. Okay. Then last is states and citizens versus non-state institutions. So state versus non-state institutions and citizens versus non-state institutions. Article 324, for instance, talks about the power of superintendence of the election commission over all elections, state elections, union elections, elections pertaining to the post of president, speaker, etc. 326 guarantees adult franchise. So it regulates the relation, and the Supreme Court has to, universal adult suffrage is guaranteed under 326 as a constitutional right to vote. There was a judgment in the Supreme Court. The Supreme Court stated that that the right to vote was not a constitutional vote, but a statutory right, which was later corrected. I forget the citation, but the Supreme Court now recognizes that under 326, it's a constitutional vote, though not a fundamental right. It's a constitutional right, though not a fundamental right. Similarly, 148 governs the powers of the CAG, Controller Auditor General, who is not a typical state institution, but what I call a fourth branch institution. Just before going to the next slide, Article 19 is very important. Now, if you look at 19 says all citizens, 19(1)(a), for instance, says all citizens shall have the freedom of speech and expression. 19(2) says that the state may by law impose certain reasonable restrictions on certain grounds. Now, ordinarily, the conventional understanding seems to be that the right to free speech and expression is available only against the state. And courts have also interpreted it traditionally like that. But if you see 19 says all citizens shall have the right to free speech and expression. It is only the state which can impose restrictions. No other body or mob can impose restrictions. So if there's a mob which is trying to ban a theater, ban a particular film, or come down and disrupt a particular shooting of a particular film on any ground that it hurts the sentiments of their followers or their caste group or their religion, then 19(1) prohibits that. So according to me, the rights guaranteed under 19, you see the broad language of 19, are guaranteed to all citizens against every institution and other person. It's a right in rem. But 19(2) confers a right on the or a privilege on the state as the sole agency which can restrict such rights on certain grounds, and provided that such restrictions are reasonable. So no other agency other than the state has a right to interfere, and if it interferes, then the courts will have a duty to prevent such interpretation or interfere with such restriction or prohibition. Non-state bodies under the Constitution are local bodies, are not conventionally, state or union, and they are institutions now recognized by the 74th and 75th, 73rd and 74th Amendment of the Constitution. Then you also have special development boards for Vidarbha, Marathwada, Maharashtra, Saurashtra, Kutch, and rest of Gujarat under 371. So therefore, there are these boards which are not conventional. So what are these fourth branch institutions? Fourth branch institutions are guarantors of constitutional democracy. Information commissions, election commissions, ombudsmen, as for example, South Africa's public protector, or India's controlled auditor general are examples of such bodies. Their importance lies in the fact that as far as certain fundamental rights are concerned, their effective realization is impossible without a kind of institutional mediation. For instance, the right to information. Right to information was always recognized as a right inhering in underlying 19(1)(a), the freedom of speech and expression, which would become non-functional without a right to information. That's what Supreme Court has held in the past. But once the Right to Information Act was enacted and information commissions were established under that act as autonomous bodies, then that Information Commission, the Right to Information Act and the Information Commission became fourth branch institution which mediated the exercise of right and guaranteed the exercise of right and gave institutional space for the exercise of such rights which are needed for its protection. So the right to vote, for example, needs an election commission to be realized. Similarly, the right to information and so on. Consequently, the independence of such bodies is an integral feature of the complete fulfillment of the right, insofar as issues such as membership and function of those bodies are to be determined by legislation. Legislation must be framed so as to ensure that the right is actually realized and be, once framed, attains the status of a constitutional statute. See, this is something that the Kenyan Court of Appeals has held in the context of its own ombudsman. But what Gautam Bhatia tries to say, and I tend to agree with him, is, for instance, if the Information Commission has been established under the Central Right to Information Act, and it is an autonomous body with independent powers, not removable at the will of the executive, any amendment whittling down such powers would be prohibited under the Constitution because it's a constitutional statute. When a statute enables and implements a constitutional provision, then a whittling down of that after enactment is not permissible. Not that all amendments are impermissible, but an amendment which whittles down the act, whittles down the right guaranteed and the tenure and privileges of the institution which guarantees an independence of institution which guarantees the right to know, would be unconstitutional. I think that is one of the grounds on which these amendments are, recent amendments to the Right to Information Act is being challenged. So you see, what are the non-state actors under the Constitution? Schools and educational institutions, You have, and within each such institution, you have those who hold power and those who use the resources of the institution. There's always a dynamic between those who wield power and those who are subject to such power. Those who wield the resources and control the resources of the institution, and those who use those resources, or consumers, if you like. So in the context of school and education, you have education agency, which is the owner of the institute, owners of the institution. Then you have teachers who are employees and students who you consume education, so within codes. So therefore, when you are looking at rights under 21A, 28, 29, 39, etc., which pertain to education, then we need to look at the rights of both parties. But what happens is, in the past, particularly at the commencement of the constitution, it is only those who wielded power in each of these institutions, who had resources to move the high courts and Supreme Court, who moved the court for enforcement of the rights. And these rights were interpreted almost as if the exclusive privilege of those players within the realm of those rights. Whereas the rights of teachers and students, today it is being recognized as right to education guaranteed under 21. And increasingly, the resource users are also beginning to assert their right or their space under each head of right. So if you look at place of work, master and servant, 23, 24, 41, 42, 43, 43A, and so on, talk primarily about the rights of servants or employees. In place of worship and religious and charitable institutions, there are three kinds. One, you have the trustees who are the within courts owners of the temple, or rather hold the properties and other resources of the temple in trust for the deity. Then you have clergy or the pujari who mediate the relationship between the deity and the religious relationship between the deity and the worshippers. Then you have the worshippers or devotees. So each of them enjoy the right under Article 25 and 26. And when viewed from the perspective of these three players, they'll have to be differently interpreted, and they have different dimensions. So the rights of these three players will have to be balanced, not just about right between the balancing of the right between the state and the individual, but also balancing the rights between those actors who enjoy these rights. So similarly, if you look at corporations and commercial institutions, you have 19(1)(g), 31A, and then you have the public trust doctrine, which has been sourced to Article 297 and Article 21 also. I'll talk about the public trust doctrine in some detail a little later. But within commercial institutions, you have businessmen, you have customers and clients. You have mediators who are middle people, traders and so on, who are also businessmen. So their rights will have to be differently interpreted and balanced. Similarly, if you look at industrial townships, for instance, smart cities have been designated as industrial townships. You have businessmen who own these townships. If not own, at least, for instance, the CEO of most smart cities is the district collector, or the district is the commissioner of a particular corporation. But ultimately, the technical aspects of the smart cities are regulated by certain technocrats who are able to move various levers, and the state is entirely dependent on the company which is running the smart city and its infrastructure. So therefore, in that context, suppose their face recognition software is there, which is widely used in these places. Now, what about the right to privacy of the residents? What about the rights of the employees of the smart cities? Apart from the rights of the different businesses and the rights of the business which runs the infrastructure of the smart city, or manages the infrastructure of the smart city. Article 243Q talks about an exception carved out for industrial townships. So where there's an industrial township, it need not have a panchayat or a local body. It is some kind of a holiday for democracy as far as industrial townships are concerned. There's a very pure space in the constitution. Traditionally, industrial townships have been defined as places. For instance, if Tata is running that steel plant, their employees would stay within the township. There is big township in Tamil Nadu, in Tuticorin. But now smart cities are not employees of a given state. Smart cities are smartly managed, technologically smart cities in which ordinary residents are there. But if you look at the industrial township under the definition of 243Q, it is differently envisaged from a smart city. But yet 243Q is applied, and we are yet to see if there's going to be any challenge and what would be the constitutional implications of such challenge. I have already dealt with this and shown that Supreme Court in several cases, Nandi Mukta Trust case itself says that a writ can be moved not just against an Article 12 authority, but in Article 226, it can be moved in a wider way against public bodies which are not conventionally understood as state. That was reiterated in Dr. Janet J. Paul's case. It was SRM University, where a deemed university was, the High Court, a division bench of the High Court declared that a deemed university is not authority within Article 12, but the Supreme Court held that it's an authority within Article 226. Then similarly in the Telefilms case, though they dismissed the case, the court said that if there is a statutory obligation or violation of constitution by a private party, then violator of such right cannot go scot-free merely because it is not a state. And in BCCI case, Supreme Court said, having regard to enormity of power exercised by the board, it is bound to follow the doctrine of fairness and good faith in all its activities. More recently, I conducted an arbitration in Mumbai against a company which was an NBFC, non-banking financial company, which recalled the loan of my client ahead of, it was a loan for about 6 crores. And suddenly they canceled the loan and asked my client to pay up 6 crores with interest, though he was regular in payment and had not defaulted. One of the, apart from the lender's agreement was heavily loaded, and there was no way I could have got an interim order by using the lender's agreement. But I found that the RBI prescribes a fair practices code, which is adopted by every bank and NBFC, which says that the lender should in all transactions act fairly and reasonably. So I said that the contract should be interpreted in light of this statutory duty, since its RBI is exercising statutory powers, and the Mumbai High Court granted a stay in my favor under Section 9 of the Arbitration Act, but eventually it was settled, so there was no way I could have got a proper judgment. But Supreme Court in the ICICI case was already held that the Fair Practices Code of the RBI is enforceable and private banks are bound by such a Fair Practices Code. And I've used it in Sarpesi and other cases and similar cases in Chennai. Okay, now let's look at the constitutional rights and obligations in light of education. Now, the constitutional provisions, right to life has been comprehended in Unnikrishna's case to include right to education, particularly primary education for children between the age of 6 and 14. But in fact, Article 21A more formally recognized what is already inherent in Article 21, and I would argue that Article 21 whittled down the right, because in Unnikrishna's case, Supreme Court held that every child has a right to education up to the age of 14 years. But 21A restricted from 6 to 14 years, which means, balwadis and preschool education, kindergarten, nursery, etc., was denied to those who had to depend on the state, those from the poorer sections. Although there are certain schemes of state governments and even central government possibly to establish Anganwadis, this is a right which needs to be recognized. Article 26, the freedom to manage religious affairs. In that, there are certain restrictions on education I pointed out earlier. Article 27 says freedom as to payment of taxes for promotion of any particular education. Article 28, freedom as to attendance at religious instruction or religious worship in certain education institutions. When education institutions are maintained out of state funds, they are prohibited from religious instruction or religious worship. Article 29 guarantees certain cultural and educational rights. Article 30, right of minorities to establish and administer educational institutions. As most of you know, this right has been interpreted as not the right to maladminister. So in the interest of maintenance of standards and in the interest of good administration, state agencies, state or center can pass laws, since it's in the concurrent education in the concurrent list, to regulate education institutions without interfering with the right of minorities to establish and administer educational provisions. Then 39E, tender age of children need not to be abused. Then 41 has right to education, 45 early childhood care, 51A says parent and guardian to provide opportunities for education of their children. These are the rights. Now, similarly, in employment, you have right to equality in public employment. Right to life has been included, been held to include right to livelihood. So even private employment comes under Article 21. And there are judgments which I'll refer to. Article 19(1)(g) talks about trade and profession, occupation, which includes the teacher's profession. Prohibition of begar and forced labor is guaranteed under Article 21. 23, and this right, as held in a shared labor case, is available against the private employer also. 24, there's prohibition of children in factories. 41, right to work. 39, adequate means of livelihood, equal pay for equal work, strength and health and strength of workers should be guaranteed. This 39D, equal pay for equal work, has been read into Article 14, and it's been enforced in Ranveer Singh's case and in successive judgments thereafter. But today it's whittled down, saying that pay is a matter for pay commissions, and this right is not enforced with any vigor these days. In Asian labor case, PUDR versus Union of India, there was large-scale employment of contract labor in Asian Games, and the PUDR did a study and found that most of these contract labor were not paid minimum wages. They were also not given facilities like housing, crushes for their children, proper canteens, and so on, which are set out in both the Contract Labor Regulation Act and rules, and also Interstate Migrant Act. Supreme Court said that since Article 23 prohibits begar and forced labor is not merely asking people to work under a whip, but if you pay substandard wages, which is sub-minimum wages, and they are forced to work because their demands of their stomach and because of poverty, that is forced labor. And Supreme Court held, we're making somebody work with wages which are below statutory minimum wage amounts to 23, violation of 23, which is prohibited. Then these are all some of the acts, labor enactments, which can be looked at as constitutional enactments, constitutional laws, because these are constitutional statutes, because they enforce constitutional provisions. So looked at this way, we need not, it is not just the text of the entire constitution, bad text of the constitution, but also laws. For instance, untouchability has to be prohibited by law. And therefore, SC/ST Atrocities Act and Civil Rights Act have to be read as an extension of Article 17. And if the provisions are amended so as to whittle down that right and prohibition, then they can be interfered with by courts. In DK Yadav versus JMA Industries, it was an industrial disputes case, and the Supreme Court looked at provisions of Section 25F, 25FF, FFF, which says that whenever there is a retrenchment, you have to give a notice of 1 month, reasons, and also 15 days wages for every year of continuous service. Similarly, if there are more than 100 workmen, then 25N applies, which means that you have to get prior approval of the government. The employer needs to get. So Supreme Court held that the procedure under 25F, etc., are procedures established by law under 21 to interfere with the right to life, with human dignity, or with right to livelihood. So therefore, the Supreme Court held that such laws will also have to meet the test of Article 14. So in this case also, Supreme Court recognized that Industrial Disputes Act is a constitutional enactment statute, which guarantees rights under the Constitution to workers. And in that sense, labor courts and industrial tribunals are also fourth branch institutions, which are not conventional courts, civil courts, because they have a right not just to enforce a contract or a settlement under Section 18 or Section 12, but they can also vary the contracts. So that is a power given only to constitutional bodies. Then you have the classic case of Visakha versus State of Rajasthan, a judgment which has had a wide impact across the country and a welcome move in 1997. But the underlying constitutional principle is as important as the judgment itself, because the Supreme Court held that when there is sexual harassment in the workplace, a woman is denied the right to live and work with dignity, which is guaranteed under Article 21 and other rights under 14, 15, 19(1) and the fundamental duties under 91, 51A and E. So these are provisions which the Supreme Court has referred to. In other words, Supreme Court recognizes the right of women separately from the right of men. And today, in the context of transgender rights, we need to look at the right to work of transgender communities, the LGBTQI communities also. So gender equality includes protection for sexual harassment and right to work with dignity, which is a universally recognized basic human right. It shall be the duty of the employer or other persons in workplace or other institutions to prevent or deter the commission of acts of sexual harassment and to provide the procedures for resolution, settlement, or prosecution of acts of sexual harassment by taking all steps required. So Supreme Court places the burden of enforcing article or protecting in the Article 21 and other constitutional rights on the employer who wield power and own the resources in the space of employment. So complaints committee should be headed by a woman. In other words, the complaints committee is a body which enforces, which is an institution, which is a fourth branch institution, which enforces these rights. So that is the way we need to understand the structure of the Act and its institutions. And today we have the Prevention of Sexual Harassment Act, which is called POSH Act, which is pursuant to the judgment in Vishaka's case. Not just in education and employment, but also in sports, health, and housing, Supreme Court has held that the constitutional rights are enforceable. In BCCI was the Netaji Cricket Club. What the Supreme Court has said is, having regard to the enormity of the power exercised by the board, it is bound to follow the doctrine of fairness and good faith. I've already dealt with this. And in Consumer Education Research Center of the Union of India, Supreme Court has held Article 21 not only includes the right to health of employees, but also applies against private employees in the context of occupational health hazards caused by the asbestos industry. In Zoroastrian Cooperative Housing Society was this, Article 12 is not applicable to cooperative society, and thus person has no fundamental right to become a member of a voluntary association or a cooperative society governed by its own bylaws. This was what I would consider a slightly retrograde judgment, because there the housing society made a law that it is a Parsi building and no part of the building or the flat within that society can be sold to a non-Parsi. An individual who was a Parsi sold his flat to a non-Parsi. Both the High Court and the division bench of the High Court struck down that clause in the bylaw, saying it's violative of various provisions, including, I think, Article 17, I'm not sure. But on the premise that a cooperating society is not amenable to Article 12, the Supreme Court reversed the judgment of the High Court and held that since you voluntarily entered the society, you have to abide by its bylaws, and you cannot resile from its obligation, although the Transfer of Property Act was also in conflict, since there cannot be a clog on title. So, but surprisingly, Supreme Court had a very conservative interpretation. It is my opinion that it is no longer good law, since today we recognize that the rights are enforceable not only against an authority under Article 12, but an authority under Article 226 and a fourth branch institution as well. In fact, I'll be referring to the judgment in Marsh vs. Alabama of the Supreme Court in 1946, which was followed by the Indian Supreme Court in Ramana Shetty versus International Airport Authority in 1979. It was cited with approval. I will come to that. I have a slide on that. I would argue that once that judgment is there, though it's in 2005, I wonder about the validity of this judgment or the continued. I would think that it's per incurium, but it's not for me to pronounce upon it. In PFA versus Kerala, there's an agreement clauses that prohibit keeping a pet in residential units. Illegal. Okay. Now, recently, People for Animals versus State of Health, the state of Kerala, there was an agreement in a housing society which prohibited keeping a pet. And so the resident who wanted the People for Animals challenged that bylaw in the High Court of Kerala, and the court held that such a rule was unenforceable because Article 48A and 51, they said Article 21, the privacy, right to privacy includes choice of pets, right to choice of pets, and Article 48A, which talks about environment, and 51G, which talks about duty to protect and conserve environment and compassion to all living things, includes keeping of pets. And they held that this bylaw was contrary to these provisions of the Constitution, including Article 21. So I would say that the Kerala High Court has not referred to the Zoroastrian Cooperative Housing Society, but I would take it as an updated understanding of the Constitution by the Kerala High Court. Very interesting judgment. It was 2021, I think about 2 months ago. Then, before moving on to rights of in places of worship, which is a very interesting and challenging challenging institution, I would go to the public trust doctrine, which is a very interesting doctrine, which has been used to rein in businesses and private players. So, what is the public trust doctrine? The ancient laws of Byzantine Emperor Justinian held that the sea, the shores of the sea, the air, and running water was common to everyone. The seashore, later defined as waters affected by the ebb and flow of the tides, could not be appropriated for private use and was open to all. This principle became law in England as well. This was when tidal waters, some rights were given about navigation in tidal waters, and these were quashed by the court, saying that these are not for the state to use as its property, but it should be open to all members of the public. And that was the origin of the public trust doctrine. Centuries later, Magna Carta further strengthened public rights. At insistence of English nobles, fishing weirs which obstructed free navigation were to be removed from rivers. So therefore, though we recognize Magna Carta as the source of individual rights traditionally in our traditional constitutional wisdom, one also sees that it also strengthened public rights over public resources. MC Mehta was Kamal Nath Supreme Court first in 1997 propounded this and said, our Indian legal system, which is based on English common law, includes the public trust doctrine as part of its jurisprudence. The state is the trustee of all natural resources, which by nature meant for public use and enjoyment. Public at large is the beneficiary of the seashore, running waters, airs, forests, and ecologically fragile lands. The state as a trustee is under a legal duty to protect the natural resources. These resources meant for public use cannot be converted to private ownership. This is what the Supreme Court has held. Then, actually, the public trust doctrine in its modern form has been propounded by Joseph L. Sachs, professor of law in the University of Michigan. He said in an erudite article, Public Trust Doctrine in Natural Resource Law, Effective Judicial Intervention, he talked about 3 types of restriction on governmental authority are often thought to be imposed by the public trust. First, the property is subject to trust must not only be used for a public purpose, but it must be available for use by general public. So this is distinct from the public purpose as understood in certain laws, particularly Land Acquisition Act. So it is not just for a public purpose, but it must be available for use by general public, like a park, for instance. Second, the property may not be sold even for a fair cash equivalent. And third, property must be maintained in particular types of uses. So if they are meant for certain use, for instance, a bridge or a park or a swamp, for instance, has to be conserved for that particular use. So 3 kinds of restrictions he finds flowing from the public trust doctrine. This is a very important and one of my favorite judgments. This arose in the context of the Ambanis having been given, I think, about 11 wells for prospecting and for oil mining mining of natural gas in the Krishna basin. And after these rights were assigned to the Ambanis, there was a rift between the Ambani brothers, Mukesh Ambani and Anil Ambani, and they had 2 companies, and they decided to partition these wells amongst themselves. So they went to the Mumbai High Court, and under the provisions of the old Companies Act of 1956, I think 397, and other related provisions, they asked for a scheme for division of these oil wells and the revenue from these oil wells. So a scheme was formulated, and the Supreme Court also set seal on that scheme. The Bombay High Court finalized that scheme and approved that scheme. Then the court directed these companies, RNRL, which belong to Anil Ambani, and RIL, which belong to Mukesh Ambani, divided these, the court directed them to come up with a documentation or an MOU in implementation of that scheme. So they framed an MOU as to how these wills will be divided, how these revenues will be divided, etc. And Mukesh Ambani's group, that is RIL, sent the MOU with an amendment, the draft. They said all this will be subject to the approval of the union government, central government, that is MOPNG. Anil Ambani's group, RNRL, objected to this, saying this was never there in the scheme sanctioned by the court, and they saw it as an interpolation by Mukesh Ambani's group, who had then some kind of greater influence over the union government than Anil Ambani's group. So they challenged it in the Bombay High Court, and eventually it landed in the Supreme Court. And Justice Subhash Reddy and Justice Sadasivan, Chief Justice Sadasivan, have authored that judgment. It's a brilliant judgment, I think the only one of its kind, which operates at the intersection of the Constitution and the company law. It's a treat to read that judgment, particularly Justice Subhash Reddy's concurring judgment is a piece of literature rarely seen. So in that, the Supreme Court has held the Constitution envisages exploration, extraction, and supply of gas to be within the domain of governmental functions. It is the duty of the Union to make sure that these resources are used for the benefit of the citizens of this country. Due to shortage of funds and technical know-how, the government has privatized such activities through mechanism provided under production sharing contract. It would have been ideal for the PSUs to handle such projects exclusively. It is commendable that private entrepreneurial efforts are available, but the nature of the profits gained from such activities can ideally belong to the state, which is in a better position to distribute them for the best interests of the people. Nevertheless, even if private parties are employed for such purposes, they must be accountable to the constitutional setup. So, in fact, there are very interesting passages in that judgment. One of my favorite passages is Justice Subhash Reddy says, he begins the judgment with a Latin maxim, which I'm unable to repeat, but it means that public law cannot be changed by private pacts. That's the entire theme song of that judgment, that you cannot distribute oil wells partition oil wells as if it is your private property. Ultimately, the government approval has to be there since it belongs to the union. In fact, Supreme Court goes as far as saying that the oil, gas, and other resources, natural resources, do not belong to the government. They vest in the people of India, and the state holds them in trust for the people of India. And then they say that when you are dealing in natural gas and petroleum resources, the public trust doctrine continues to play a part till it reaches the end consumer. So from the oil rig owner to the refiner to the wholesaler stockist to the petrol bunk owner, till the gas or the petrol reaches the tanks of our car, it remains public trust property. It becomes private property only when it enters the domain of the end user. In fact, I am a counsel for GAIL and ONGC. I use this public trust doctrine a lot, particularly when there are companies which are allotted gas, and often there are amalgamations and subject to various manipulations and price disputes and so on. So I use the public trust doctrine a lot when dealing with those cases, saying this is not an ordinary article of commerce. This is even the company which is an allottee of natural gas is subject to public trust obligations. Now we come to constitutional places of worship. What are the rights of different players in the place of worship? As I delineated, I talked about the rights of the trustees of places of worship. I talked about, whether they be temples, mosques, or churches. Then I talked about the rights of the clergy, the priests, the pujaris, and the maulvis, and the mullahs, and the imams, their rights, and the rights of the common worshippers. So some of the provisions, Article 17 talks about untouchability, which was because religion, Hindu religion at least under certain interpretation, sanctioned untouchability, and today that is prohibited, and happily to a large extent, though it survives in certain pockets, and some forms of untouchability still survive in India. Hardly the fight against untouchability has been a successful one. Article 21, right to life and personal liberty, the right to be treated with human dignity even in a place of worship is guaranteed. Article 25 talks about freedom of conscience and religion. So therefore, it is not merely the right of a worshipper, but a right of an atheist is also protected under Article 25, though in practice, rights of atheists are seldom recognized or articulated with any force. However, the state's power to regulate secular activity associated with religious practice is preserved. Similarly, providing for the state has the power and duty to provide for social welfare and reform or opening of Hindu religious institutions of public character to all class and sections of Hindus. So all class and sections of Hindus also include all genders or all sexes, women and LGBTQI community. This is what was held by Supreme Court in the Ayappa judgment, but it's under review now. Article 26, freedom of religious denomination, 27, 28, and 30. We've already dealt with this. Now let's go to Marsh versus Alabama, the judgment I spoke about, which talked about the right to practice and propagate religion as well as free speech. The facts were this. The town of Chickasaw, Alabama was owned and operated by Gulf Shipbuilding Corporation and surrounded by a number of adjacent neighborhoods that were not on Gulf property. Gulf property means the company Gulf. Its policeman was a deputy from Sheriff's Department who was paid by the Gulf. We have a parallel, I'm sure you all know, customs officers, for instance, under the Customs Act, they can be loaned to private container stations, and the salary for them is paid by the private employers, though they continue to be officers of customs. So it's not just an American custom, it has been imported by India as well. Grace Marsh, a Jehovah's Witness, distributed religious literature in the town. Marsh was warned that she needed a permit to do so and that none would be issued to her. When she asked to leave, she refused on the grounds that the company rules against distribution of such materials could not constitutionally be applied to her. The sheriff arrested her and she was charged with trespassing under the Alabama Criminal Code. The US Supreme Court held that a person distributing religious literature on the sidewalk of a company town was protected by the First Amendment rights of freedom of press and religion and could not be arrested for trespass. So the US Supreme Court held generally towns are managed by municipal authorities, and merely because a private township is owned by a private company and it was exercising municipal functions, such private company, when exercising such municipal functions, would be bound by the Bill of Rights in the US Constitution, including the right to practice and propagate religion and the right to free speech. The owners of privately held bridges, ferries, turnpikes, and railroads may not operate them as freely as a farmer does his farm. Since these facilities are built and operated primarily to benefit the public, and since their operation is essentially public function, it is subject to state regulation and subject to constitutional limitations placed upon state action. So this is what the Supreme Court has held, of US has held in Marsh versus Alabama, and it is very wide. This, as I said, this judgment has been quoted with approval in 1989 by 1979 by our Indian Supreme Court in Ramana Shetty versus International Airport Authority case, and it is especially relevant in the context of public-private partnership and PPP projects, which are increasingly governing or increasingly resorted to in major infrastructure projects. So, place of religion in the Constitution. Aladi Krishnaswamy Iyer in the Constitutional Drafting Committee said, there is no religious question that is also not a social question. And I would add a constitutional question as well. Dr. Ambedkar said, religion is a private matter. It should not impinge on public policy. That is unfortunately a wish which is practically proved impossible in India. Unfortunately, the religions which prevail in these countries are not merely non-social. So far as their mutual relations are concerned, they are anti-social. One religion claiming that its teachings constitute the only right path for salvation, that all other religions are wrong. So Ambedkar saw that religion itself was antisocial, or at least the practice of religion. Religion in its practice tended to be antisocial, even if at a doctrine level it was not so. So Indian Young Lawyers Association was the state of Kerala, which is the historic temple entry, Sabarimala temple entry case. This is what the Supreme Court has held, particularly Justice Chandrachud has waxed eloquent. Religion is a way of life intrinsically linked to the dignity of an individual, and patriarchal practices could not be allowed to impinge upon the fundamental freedom to practice and profess one's religion. Exclusion of women between the ages of 10 to 50 years practiced by the Sabarimala temple denuded women of their freedom of worship guaranteed under Article 25(1). So here the Supreme Court has specifically looked at Article 25(1) and interpreted that right under 25(1) in the case of women as inhering certain aspects, which may not be so in the case of men or the trustees of the temple or the pujaris of the temple, clergy of the temple. The temple's denominational right to manage its own internal affairs under 26B was subject to state social reform mandate under 25(2)B. Worshippers of Ayyappa do not constitute a separate religious denomination. Specifically, Article 25(2)B allows the state to make any law that opens a public Hindu institution to all classes and sections of Hindus. Classes and sections include the gendered category of women. The fundamental right of women between the ages of 10 and 50 to enter the Sabarimala temple is undoubtedly recognized by Article 25(1). The fundamental right claimed by the tantris and worshippers of the institution based on custom and usage under the self-same Article 25(1) must necessarily yield to the fundamental rights of such women as they are equally entitled to the right to practice religion, which would be meaningless unless they are allowed to enter the temple of Sabarimala to worship the idol of Lord Ayyappa. Here, this is a case where Article 25(1) explicitly sees that there is a conflict or an attempted conflict between the rights of women worshippers and the rights of the tantris and other, probably the clergy and trustees or tantris of that temple. Their right to exclude women based on custom, etc., has to yield to the right of the women under Article 25(1) of the Constitution. It struck down Rule 3B of the Kerala Hindu Places of Public Worship Authorization of Entry Rules of 1965. Exclusion of women between ages 10 to 50 by the Sabarimala temple cannot be an essential religious practice. Indian Constitution is transformative in two distinct ways. This was the exposition on the transformative potential and transformative power and role of the Constitution. So the Indian Constitution is transformative in two distinct ways. First, in setting up governing institutions of an independent republic transitioning from colonial rule. So first is, once we have an independent judiciary, once we have a parliament which is answerable only to the people of India and elected by the people of India, representative government, etc., which was not possible under the colonial rule, although the Government of India Act of 1935 and previous Government of India Acts provided for limited provincial governments and Indian participation in such government. This constitution enabled a transition to independent Indian rule with governing institutions. That was the first transformation. Second, he says, placing those who are denuded of their human rights before the advent of the constitution, whether in the veneer of caste, patriarchy, or otherwise, in control of their own destinies by the assurance of the equal protection of law. So therefore, first was political democracy. It transformed India from a colonial feudal nation into an independent political republic with representative democracy and institutions, vibrant institutions which guaranteed such democracy, not just the three branches of government which are conventionally part of the state, but also non-state institutions, the Election Commission, Comptroller, Auditor General, etc. Second is social transformation, where the rights guaranteed under Part 3 and Part 4, which are fundamental to the governance of the country, enable or facilitate the exercise of human rights by various groups, which are often hindered not just by the state. It is not only state which threatens human rights, but also caste hierarchies and patriarchal hierarchies and other conventional hierarchies, which inhibit the exercise of rights by the people. And therefore, I would argue that as citizens, see, prior to the Constitution, we were subjects of the British rule. But once we became citizens, formally recognized as citizens, full exercise of the right of citizenship is not merely by restrictions of the state, but also by micropowers, exercising caste dominance and patriarchy and other conventions. The reference to caste and patriarchy is important because it acknowledges that discrimination is not limited to state action or even to hostile individual action, but it also flows from institutional design. Caste and patriarchy are neither state nor an agglomeration of individual acts where you can attribute discriminatory agency to identify individuals. They are social institutions. So therefore, you see this judgment has, beautiful incisive analysis, I would say, where they say, on the one hand, the Constitution protects about the invasion or infringement of rights by state and its agencies. Two, it also protects you from institutions, infringement and restrictions on rights by individuals who are powerful individuals who man various bodies, including places of worship and places of educational agencies and places of work. But it also guarantees the exercise of rights from conventional institutions, which are social institutions like caste and patriarchy. Even those institutions, the Constitution is a bulwark in protection of rights guaranteed under the Constitution against such institutions. This kind of articulation is quite rare, but very powerful and is potent to expand the rights of the Constitution and build the nation rather than brutalize the state. So in India, temple entry movements have created a long history and has always been framed in the language of civil rights and access to public spaces. If you see Article 15.2, for instance, it talks about access to public spaces, not just government-owned spaces. This was especially true of the great caste-based temple entry movements of the 1920s and 30s. This substantiates the argument that in India, the thick character of religious life implies that you cannot simply wall it off from the rest of social life. Consequently, discrimination within religion is hardly an isolated event. Discrimination within religion both reinforces and is reinforced by discrimination in broader social life. So if you permit and tolerate discrimination within religion, then it will definitely impact broader cultural and social life. Reading Dr. Ambedkar compels us to look at the other side of independence movement. Besides the struggle for independence from British rule, there was another struggle going on since centuries, which still continues. That struggle has been for social emancipation. It has been the struggle for replacement of an unequal social order. It has been a fight for undoing historical injustices and for righting fundamental wrongs with fundamental rights. The Constitution of India is the end product of both these struggles. It is the foundational document which in text and spirit aims at social transformation, namely the creation and preservation of an equal social order. The Constitution represents the aspirations of those who are denied the basic ingredients of a dignified existence. This is what the court says in paragraph 74 of its judgment. The meaning of fundamental rights ought to be determined by asking the following question: what was the legacy of injustice that the Constitution sought to acknowledge and then transform? That legacy was defined by social hierarchies and social subordination. At its most virulent form, this took shape of caste untouchability. So untouchability is not the only evil. There are other associated evils which are less draconian or less virulent, but equally divisive and which engender deprivation. The incorporation of Article 17 into the Constitution is symbolic of valuing the centuries-old struggle of social reformers and revolutionaries. It's a move by Constitution makers to find catharsis in the face of historical horrors. It's an attempt to make reparations to those whose identity was subjugated by society. The caste system represents a hierarchical order of purity and pollution enforced by social compulsion. Purity and pollution constitute the core of caste. The caste system has been powered by specific forms of subjugation of women. The notion of purity and pollution stigmatizes the menstruation of women in Indian society. In ancient religious texts and customs, menstruating women have been considered as polluting the surroundings, irrespective of the status of a woman. This single event of exclusion is nested in an entire social and institutional order that is characterized by hierarchy, subordination, and exclusion. Recognition of the institutional character of discrimination and inequality and how that may be constitutionally combated. That is the function of the Constitution, according to the Supreme Court. So, places of work, worship as places of work, rights of women against social harassment. You have numerous ashrams and even masjids and churches where sexual harassment takes place uninhibitedly often because of the immunity and that is available to the priests and Maulvis and the pastors and the Christian priests. Yet, very little is talked about implementation of rights against sexual harassment or the sexual harassment law against these ashrams, which house young people. Paramananda Swami, whose real name was Aravindan Balakrishnan, who would first isolate his victims from family and exploit them. An 8-year-old girl was sexually assaulted by Maulvi in a madrasa at the Gautam Buddha Nagar district in Noida. Baba Amarpuri, who worked in the Baba Balaknath temple, would drug women and then rape them. Haryana godman Baba Amarpuri was arrested for raping 120 women. Bishop Mulakkal, who was arrested for allegedly raping a nun multiple times, came to light last year and sparked a huge debate in terms of applicability of laws that protect women insofar as religious institutions are concerned. An astrologer named Ashu was accused of raping a woman and her minor daughter at his ashram in the House Khas area in Delhi, and Muslim women being sexually harassed and raped in mosques and at the Hajj on a Hajj at Mecca. Asaram Bapu was convicted of rape on 16-year-old girl, a devotee at his ashram in Jodhpur in April 2018. Swami Nityananda absconded from country following criminal case of rape and sexual assault. Isn't there a necessity to regulate ashrams and madrasas and implement the POSH Act in places of worship? These are some of the, we are treating places of worship as some kind of citadels which and forts which state should not enter, which the constitution should not enter. As long as this kind of an attitude prevails, our young people, our children, nephews, nieces, grandchildren will be in danger. And from often it is easy to bring a politician to book, but to bring a religious head to book under such allegations has been very difficult. And fortunately, because of the courage of several victims and the courage of those who protected them and went after the perpetrators, has enabled these incidents to come to light. But these need to be, it is important to work for the enforcement of, there should be we should ask for internal complaints committees in each religious place of worship, because there's ample evidence that these are being abused. Temples and equalities, non-Brahmin priests. Temple entry movements in different parts of the country. Sri Mahadeva Temple in Baikom, entry of Dalits led by Periyar in 1924, enabled there was participation of women in these movements. Temple entry proclamation in 1936. It resulted in temple entry proclamation in 1936. 12 years ago, 206 men joined 6 training schools located across Tamil Nadu to receive instruction to become priests. These archakas were set up by Tamil Nadu government to train non-Brahmin priests. Only Mr. Marichami, a non-Brahmin trained under the Tamil Nadu government's Archakas training center between 2007 and 2008, wherein 216 people across castes were trained for priesthood in major Shaivite and Vaishnavite temples. After the first batch graduated, the program was shut down. He was appointed as a priest in August 2018. More recently, I have not updated this slide. After the DMK government came to power, several people, including Brahmins and non-Brahmins, were arrested appointed as archakas of the temple, and the DMK government has been doing much to promote non-Brahmin priests in temples. Now, this is very important because, see, traditionally, right under Article 2, right to practice religion under Article 25 has been held to apply or interpreted more as the rights of the archakas of the temple, rights of priests and rights of the trustees, or in the context of church as the rights of the the people who govern the church or govern the mosque, rather than rights of common worshippers. But here now it is necessary not just for the worshippers to exercise rights. It's important for common worshippers of all castes and genders to participate in the governance of these institutions and participate in the using and governance of the resources of these institutions. Liberty, so that is why I already said that historically, if you look at the French Revolution, liberty was not against the king alone, but also against the clergy. So democratic revolutions should be not just against the king or the state. Democratic religions should be against, should call to account and enforce accountability against all institutions which wield power, whether it be secular power or religious power. So religious institutions and leaders who control these institutions affect the constitutional rights of common people and hence have constitutional obligation not to infringe on those rights. We know about caste and patriarchy in religion. The issues in state of Tennessee versus John Scopes in 1925. There's a film called Inherit the Wind, which I often use in my constitutional law classes in Nalsar and other universities where I teach. That was a case where a teacher was brought to trial for teaching Darwin's theory of evolution against a law which mandated teaching only of creation, which is prescribed in the Bible. And he was convicted, though Clarence Darrow, the famous human rights lawyer of US, defended him. And eventually, the Supreme Court struck down that law and other similar laws, where the teaching of Darwin's theory of evolution was prohibited. This Inherit the Wind is available free on YouTube. Those who have not seen, please see the movie. It is a fantastic movie. I wish such movies are made on the Indian Constitution and some of the cases in India, so that there is a more popular understanding of the substance and meaning and the transformative potential of the Indian Constitution. So non-discrimination against different believers. The need for democratic and constitutional accountability of these institutions. Need for organizational structure ensuring reform and accountability. Need for non-Brahmin and women and LGBTQI priests in all temples and religious institutions. They're talking about gay priests in Europe and England and other places. It's about time we also ensure that we have priests not just from women, but also LGBTQI and apart from non-Brahmin priests. Need for reservation for OBCs, Dalits, and women in executive committees of religious institutions. This is something which is important according to me if we have to attain the move towards a transformative goal that the Constitution envisages for the country. So as Ambedkar said, it is not just the state which is tyrannical, power of social tyranny is greater. And these institutions like religion, caste, family, and culture often exercise micro-powers which can have a tyrannical effect. Particularly, we know the kind of things that are happening to intercaste marriages. Intercaste couples are in great danger. And often today, POXO is being misused by parents of women, young girls who are in love with people who are from different castes or different religions and different economic backgrounds. So power dynamics in a religious institution would be, on the one hand, priests versus worshippers, and worshippers versus non-believers, community elders versus members in the case of a caste, and the case of family and culture, patriarch versus women and children. So these are power dynamics, and the fundamental rights, constitutional rights will have to be understood in the context of this power dynamics, in the context of relationship between the wielders of power and the people who are subject to such power. I've already talked about king versus pope and Bali versus Vamana. Justice Ramakrishna had commented on my Bali versus Vamana metaphor. See, what it is not about, it is not about what it is rather trying to understand the structure of the myth, to understand the struggle between the state and the church in the Indian context. This is the nearest myth I could take. And in the absence of historical struggle, we need to make meanings. See, today, myths are making a lot of meaning. And for instance, Rama as as a national figure is being projected by the ruling party, and more governance is being done on a religious idiom. So it's important to understand religion and myths and the stories that common people believe in a constitutional context, so that we get key insights for transformation. That is what I was trying to do. So therefore, coming back to this, what I was talking about was, at one level, it's an instrument of governance. It's important. It's also an instrument of social transformation. So the Constitution is playing a dual role, and both are important, and one cannot be at the expense of the other. And the nation and the state are both important. The state exists for the nation, and nation does not exist for state. And the attempt to conflate the state and pretend that the state is the nation has to be put down with a firm hand, if we are going to prevent tyranny and ensure that democracy grows in the country. And this is the Ambedkar's address, which I started with. And this is the hope that I leave with, that it's not just courts in India, but lawyers and other people like us who can carry forward the transformative potential of the Constitution and the democracy, and including social democracy, that it envisages. I always, in my classes, I like this example about social democracy. When people ask what is social democracy, one example I give is this: in this country, you have a right to choose elect the prime minister, but you do not have the right to choose your own life partner in most cases. That is what social democracy is about. Social democracy is the right to choose my life partner, right to choose whom I date, right to choose whom I go to bed with, right to choose whom I accommodate in my house. These are all rights which are more important to me than who the prime minister is. I'm not undercutting that right. It's equally important. But these are social rights. This is what the stuff of social democracy is. People think that social democracy is something esoteric which cannot be defined. Social democracy and privacy and such rights can be defined in simple terms. So thank you for your patience and for listening to whatever I had to say and my views.
Shyam, ghost is missing.
It's not there.
No, sir, he's not missing. He's I'm the host now. Ramkumar sir, your kind words on the presentation, sir.
Thank you. Thank you. Excellent articulation, Mr. Giridhar, especially on the special category of fourth branch institutions and the restrictions on the state as a trustee of the people in the matter of outsourcing the natural resources, etc. Beautiful articulation. And I think that special economic zone is the industrial township you were talking about, where
Also.
the ordinary laws are not applicable. No.
Yes, also. But
Special economic zone.
But they are. I don't think they are industrial townships under 243Q, but they are similar. Yes.
I see.
Yeah. If you see, I think Jamshedpur is an industrial township.
I see.
And smart cities have been recognized as industrial townships. For instance, if you see cantonments are also have representative bodies with limited rights, but industrial townships do not appear to have such representative bodies.
Excellent. Thank you. Thank you. I take leave because I got a function to attend.
All right, no problem.
Oh, yes, thanks for being there, sir. Justice Ramakrishnan, sir, you'll have to unmute yourself and a few words.
Thank you, Justice Ramkumar.
I think there is some problem. Bishop, how do you get? We are having a problem. Just a moment, sir. My apologies. Yeah, I know, but it's not. Something is going wrong. Because they made me the host. I think we're having a slight problem. So just bear with me, Justice Ramakrishnan. This is participation.
Can someone else comment in the meanwhile, maybe?
Yeah. Yes, sir. You can. I think you can unmute now,
Yes,
sir.
now we cannot. Really
Yeah.
nice presentation, Mr. Giridhar, on these aspects. And it's a new area where you have explored the possibility of constitutional provisions which can be used for the purpose of benefiting and also exercising the powers of the first institution in a right way. As regards the right of Archakas, etc. are concerned, Kerala High Court has held an Adityan versus Travancore Devasam Board case, where it said it is not the right as such to a particular community or something, that those who are qualified to be an Archaka can be appointed irrespective of the religion. That, I think that is one decision by the Kerala High Court.
Which
I
year?
do not whether I do not know whether it was taken to Supreme Court or not, but there is a one High Court, the decision of the full bench headed by Justice Thomas. That view was taken in that case. Really, it's a eye opener where regarding the right to choose, etc. If it has been liberally construed, I don't think that your the concept of society or marital nature, etc. will go. But anyhow, for the purpose of marriage, you can say at least I have got a right to choose a person of my choice and marry. Otherwise, if you in the lighter sense or in the liberal sense, it is taken now. It is going for living together, just like etc. I do not know how far it is good for the society. Anyway, there is a right. That right cannot be denied, because whenever a person is there, person has got inculcated himself with some rights. That right cannot be restricted by anyone, because he can exercise right subject to the law of the land. That is the only thing. Anyhow, it's a very eye opener where the Constitution has provided the provisions, but how far it will not be interpreted for the purpose of achieving the purpose for which the Constitution was denied. Thank you very much.
Thank you.
Thank you, Ramakrishnan, sir. Sir, with regard to living relationship, most of the courts are now held it to be illegal. In fact, they've gone one step further to say that she is entitled to maintenance also. If they happen to.
That is because of the DV Act.
Domestic Violence Act.
Exactly. So even though it's a live-in relationship and not a marriage, they still say it's a domestic violence under the
living in the nature of a marriage. In the nature of a marriage.
The domestic act basically is for married couples, and not otherwise. But now it has been brought in, encompassed into that. So we have to learn to live with that. Prem sir, are you there, sir? Okay, sir. So then I will take the liberty of
concluding.
Yes, sir. Yes, sir. Giridhar sir, excellent articulation, well presented, well explained. I don't think you left anything for doubts for anybody. And as usual, you've been your normal self, calm, composed, and I mean, like, you know the subject very well, so I don't need to expand on that. And regarding to R. Shetty and Airport Authorities of India, that is when all public sector undertakings or corporations or third agencies of the government were brought under Article 12 to be considered a state. So you're very right on that. And the only takeaway from that would be that even though they are a state under Article 12, they are not public servants protected by 197. 197 because they are the third instrumentality of the state and don't draw salaries directly from the government. In fact, if we go to Mohammad Hadi Raja Hadi, he's gone one step further and said even IAS officers on deputation to corporations or to societies lose their protection under 197. So you have to think 10 times before taking up a deputation to think that you're still a state employee and not the employee of the corporation. Anyways, very well articulated. We thank you very much. And we are very happy to have you and wish to see you again on the forum as a participant, and also to speak on other subjects as and when Shyam sir and Prem sir deem it fit. I thank each one of you all. Justice Ram Kumar is not here, he is gone, but I still thank him. Justice Ramakrishnan sir, also I thank you very much for your presence, sir. It really helps us a lot. And I thank everybody for participating today, and see you tomorrow. Shyam sir will send. Yes, sir.
Giridhar, I think that there is a difference. The view on cooperative society, I think now little change it appears. Cooperative society is also brought under section Article 12. It appears.
Correct. Now there's a change. Correct.
Some decisions
Yes.
are there.
True. That's why I said I don't think any longer good law.
That has
No,
come
so that is, sir, but even though they bought under Article 12, 21 of the IPC doesn't protect them.
No, that is not there. But for the purpose of challenging their the decisions, etc. Earlier, you will have to go only under the Cooperative Societies Act. Before the registrar. Now, wider. And other thing you are rightly said, PPP has come for all things, but thereby the state is what you call dehorring the responsibility of providing health, education, etc., which they are expected to provide.
Yeah. Exactly.
Once it goes thereafter, once it goes to the PPP, then automatically your article for 24, 25, everything will come. Then it will be very difficult to come out of that. It's high time that it will have to take back to the state itself.
National Monetization Pipeline, NMP, envisages transferring many of these assets to private hands.
Now, similarly, I think that there is a national education policy also must come with some reservations as to how this will have to be implemented, etc. But because you have got a lot of syllabus which is really causing a lot of trouble to the students also. So that you have a uniform syllabus and uniform educational policy so that everybody will be having the same thing, same standard of education.
Yes, also if you're transferred, you're not losing out on subjects. I mean, the continuity remains there.
Only thing is,
So
your option for the second language or third language alone will change.
Exactly, sir. That you have to live with it. Every state wants to have their linguistic dynamics, so we cannot stop that, sir. Once again, I thank everybody for participating and thank you for being here. And good night and see you all tomorrow.
Good night. Thank you.